Thank you.
Good afternoon, everyone. Welcome to our last session this afternoon. This afternoon, we are privileged to have with us Deborah Caldwell-Stone, Director of ALA's Office of Intellectual Freedom, Executive Director of the Freedom 3 Foundation, and an attorney. Deborah will be sharing with us an overview of the ways the First Amendment protects patron access to information and the role of current and historic cases in protecting librarians while serving their community. She will review minors' rights under the First Amendment and provide some examples of how the court has addressed challenges to materials in school, including the definitions for obscenity, which is frequently used as a basis for materials challenges. So Deborah, welcome, and begin whenever you are ready.
Well, thank you, Ellen, and thank you all for spending time with me this afternoon. I deeply appreciate it. Let me get started by sharing my screen. Hold on just a second here. And we'll get past the title slide, but I do have to do something here because I am an attorney. I do have to let you know that while we'll be talking about legal information, basic legal concepts, you shouldn't consider today's session legal advice, and you shouldn't use it in place of legal representation. You really should consult with your own legal counsel, whether it's your board attorney, personal attorney, your city or county attorney for legal advice. They're the ones that are there to advise you about legal situations in your library and your community as well. So let's get started. We're talking about the First Amendment, so we should really look at the First Amendment and what it does. And what it does is to protect everyone who resides in the United States from any government restriction that places a burden on the right to speak, the right to publish, the right to hold or not hold a belief. It not only applies to the federal government, it applies to states, it applies to counties, it applies to local communities as well. This is all done through the 14th Amendment through a process called incorporation. That is the grant of rights through the Bill of Rights, the protections of the Constitution extend and apply to every government agency. And the First Amendment applies to both adults and minors. We'll talk a little bit about that later. And it applies to all speech, unless it's part of an unprotected category of speech that's been so designated by the US Supreme Court or statute. We do have to remember, though, that the First Amendment applies only to government entities, not private entities. It is not something that applies to an individual speaking for themselves, a private corporation, social media platforms. And again, we can talk a little bit more about that later. And so even though there is one thing that doesn't appear in the First Amendment, it's very important. The First Amendment protects another right. It's called the right to receive information. And the Supreme Court has consistently found and protected the right to receive information as an essential element necessary for exercising all First Amendment rights. And in the library context, when we're talking about library users' rights, it's the right to receive information that's protected under the Constitution and the First Amendment. Now, to deep dive into this a little more deeply, we have to talk about a concept called public forum. A fundamental principle of the First Amendment is that all persons have access to places where they can speak and listen, and then after reflection, speak and listen some more. What the Supreme Court identifies as a public forum. The First Amendment places limits on the government's ability to regulate speech in public forums, and the Supreme Court and other federal courts have developed tests and doctrines that govern the public spaces reserved for free speech activities in the United States. And the public forum doctrine is one such tool. It's used by the courts to determine if a restriction on speech or on speech activities that's imposed by a government agency is constitutional. That is, if the regulation or restriction conforms to the First Amendment. Courts employ this doctrine to decide whether groups should have access to an agency or other government property to engage in expressive activities. Now, there are three kinds of public forums: traditional public forums, designated or limited public forums, and non-public forums. And traditional public forums are locations such as streets, parks, and sidewalks, places for protests and demonstrations, impromptu speeches, things like passing out pamphlets at the public square. But the government agency can deliberately create a new place for First Amendment activities in places and spaces that are not usually open for public use. And these are what are called designated or limited public forums, and they can be open to the public as a whole or only open to a part of the public. And non-public forums are government-owned or controlled properties or places that are reserved for the particular business of that agency. So the law will distinguish between these three types of fora: public, designated, or non-public forums. And facilities like things like schoolhouses, courthouses, libraries, are considered to be not traditional public forums, but different kinds of public forums, like a designated public forum for the purposes of the First Amendment. Now, there are some basic rules that govern all public forums. Any content-based restriction must meet strict scrutiny. That is, there has to be a compelling government interest in regulating the speech activity that's narrowly tailored to meet that interest. And there's no other alternative that imposes less restrictions on speech. And this is a very difficult test to meet. Very few content restrictions on protected speech survive any kind of court review. Additionally, restrictions placed on opinions or viewpoints are always barred in any public forum. But a reasonable time, place, and manner restrictions, restrictions that are unrelated to content or viewpoint, are permissible. Things like the volume of sound that's allowed through amplified devices, for example, is a kind of time, place, and manner restriction. The important thing to remember is that in designated, limited, or non-public forums, the government agency administering the facility or institution is only obligated to allow those First Amendment activities that are consistent with the mission, purpose, and nature of the facility, even if the facility is otherwise open for the public. And this is important for public libraries. And even public school libraries, any facility that provides access under a limited grant of mission. So, of course, the public library is a limited or designated public forum, a place created by the government for the purpose of allowing the public to receive information. This can be reading books, browsing the internet, accessing databases, or using any or all of the resources provided by the library for its users. Because it's open for particular speech activity, in this case, the right to receive information, it's considered a limited public forum, a place open to allow individuals to have access to the information they need to be productive participants in society and to improve their lives through education, entertainment, and civic engagement. But the First Amendment doesn't require a library to provide a forum for other kinds of speech activities beyond receiving information. Courts have ruled that the First Amendment only requires libraries to provide individuals with access to the building and to the resources that are in that building. But once a library makes a choice to allow library users access to engage in some kind of speech activity within the library, the First Amendment will apply to those additional speech activities. Now, as you might suspect, schools and universities are not the same as public libraries. Because their purpose is to serve the information needs of their students and their faculty as part of the educational mission of the institution, they are non-public forums. The government has not opened them for use by the public, and the right of access is reserved for the institution's students and faculty. Thus, they're able to exercise a measure of discretion about their collection decisions. But as publicly funded institutions, they must still operate in a manner consistent with the First Amendment and respect the First Amendment rights of their students and the other authorized users of the library. Thus, given a particular set of facts and circumstances, the removal of books from a school library may violate students' First Amendment rights to receive information. And public school libraries and public academic libraries are able to limit access to their students or to authorized users for the purposes of physical access based on the mission of the institution. Now, I do want to remind you that minors do have First Amendment rights and enjoy the same right to read and receive information in the library as adult users. With some narrow exceptions, the government cannot restrict minors' access to materials that are protected by the First Amendment. The courts have protected minors' right to access information in both the public library and in the public school library. However, there are those limited, narrow exceptions that are placed on minors' right to receive information. But we'll wait and we'll discuss that a little later in detail. It's important to note that minors' First Amendment rights are personal to them and not subject to veto by parents or guardians. Minors' access to library resources or programming should not be restricted because the library doesn't have a parent's prior consent. For example, policies that require youth to submit parental permission slips to access certain books, or that limit youth access to films and video games based on rating systems from MPA or the Entertainment Merchants Association, have been rejected by federal courts as an unconstitutional burden on minors' First Amendment rights. Now, libraries, because they are limited designated public forums, do have the right to establish reasonable rules governing the use of the library. Because library patrons only possess those rights that are consistent with the mission or role of the public library, the rights to access and receive information, resources, and services provided by the library. And a library's power to regulate patron behavior is not limited to cases of actual disruption, but may be tied to safety, use of resources, and other reasonable concerns directed to fulfilling the library's mission, protecting the safety of library staff and library users, and also making sure that individuals are complying with the law. Now, there's a particular case that really illustrates this. There was a barefoot library patron, belonged to the Barefoot Society of America, and dedicated to a life without shoes, demanded that the library make an exception to its requirement that all patrons using that particular library wear shoes when they entered the library. The individual claimed that requiring him to wear shoes violated his First Amendment right to access to the library, his First Amendment right to particular beliefs. So he sued when the library refused to admit him to the library without shoes. And in defending the claim that the rule was unreasonable and a violation of the user's First Amendment rights, the library decided to provide statements and evidence in court that it was a reasonable rule. So they provided evidence that blood, broken glass, and even feces had been found on the floors of the library, and that the library had created the rule not necessarily to restrict anyone's beliefs, but to protect patrons from harm and to protect the library staff as well, and really to protect the library from any liability should someone be injured by stepping on glass or other mess on the floor barefoot. And the end result was that the court ruled in favor of the library, holding that the rule requiring shoes in the library was a reasonable time, place, and manner rule that was allowed under the First Amendment. So we can look at how this applies in particular situations. And one that's come up frequently in recent years is the First Amendment audit. There has been this loosely organized social media campaign to audit government spaces and agencies for violations of alleged First Amendment rights to access government agencies. And that's begun to target public libraries. And this is in addition to police stations, city halls, and other government offices. The individuals and groups undertaking these First Amendment audits claim a protected First Amendment right to film in any space accessible to the public, arguing that they're entitled to do so as taxpayers and citizen journalists. And when they say any, they mean any. One of the saddest videos I've ever seen on YouTube was a First Amendment auditor's video where they insisted that they had a right to enter and film people applying for welfare benefits in a particular community. And now eventually the police cleared them from the area, but to see them intrude on the privacy of individuals applying for welfare benefits in a closed government office was just one of the worst things I've ever witnessed. So anyhow, based on the output, which is, as I say, is readily viewed on YouTube and other social media platforms, their goal is to create films of their encounters with police, security officers, and any other public officials that they claim document a violation of their First Amendment right to film in public spaces. Sometimes they'll provoke a reaction from these from staff, from security officers, in order to get the content they need. The video of the confrontation is then posted online, both not only for entertainment purposes, but also for money. The goal really is to gain eyeballs to monetize advertising. But it also creates documentary evidence for a legal claim. And many of these groups or individuals have filed civil rights lawsuits against the targeted government agency, its officials, and its staff. And they seek a financial settlement or an award of money damages. Now, in beginning to target libraries, they have begun to argue that because libraries are open to the public, they can do whatever they want there. And so while the First Amendment does protect the right to film on or take videos when the person filming is located on a public street or a public sidewalk, a public square, a public park, thinking about what we know now about public forum, the First Amendment only provides full constitutional protection to the right to film when it's in a traditional public forum, but not necessarily in designated or limited public forums like libraries. They can certainly put in place regulations that limit filming, limit these activities that are consistent, so that these activities are consistent with the mission or purpose of the library, and are only expressly allowed by the library. So because public libraries can adopt reasonable policies to regulate expressive activities that are not part of its mission, that is the providing for the right to receive information, they can create content neutral rules that address filming or photography, and they can regulate behavior that impairs the operation of the library, such as harassment of other library users or other library staff. And courts have upheld regulations that prohibit filming in public spaces. There are two cases cited here on this particular side that upheld restrictions on filming in a city hall and in a public university's classroom during a public program. So it is possible for libraries to put in place reasonable policies that regulate behavior that protect library users' privacy, their ability to use the library undisturbed, and that protect the library staff from harassment. So consider adopting written policies that allow for photography and filming of the library building that does not invade the privacy of library users. And we have to remember, many people visit libraries to view architecture, evaluate the collection, or see historic documents or artifacts. And they may want to take a photograph or film of these items, create a record of their visit. And all of that is perfectly fine, and we should welcome that for people who want to visit the library for that purpose. But you can address filming in the library as a behavior issue or a media relations issue. Policies should be written so that the library can address any disruptive activity that interfere with the ability of the library staff to do their work or invade the privacy of library users. Another important step I might recommend in regard to these auditors: make sure that you clearly identify non-public spaces in the library that are not open to the public, or where users have an expectation of privacy, such as washrooms, reservable private study spaces, offices, break rooms, and work areas. So we should recognize that the First Amendment does not require a library provide a forum for other kinds of speech activities beyond the provision of books and information resources. The courts have ruled that the First Amendment only requires libraries to provide individuals with, as I said, with access to the building and resources that the library provides in the building. But a library can choose to provide more. And once the library makes a choice to provide meeting rooms to library users to gather, to engage in conversation, to hear programs, the First Amendment will protect that additional speech activity. So if you have meeting rooms that are open open for use by the public. Display cases, other spaces available for public use. We are creating another designated public forum for speech activities. Any rules or restrictions placed on the use of meeting rooms need to meet the more stringent First Amendment strict scrutiny standard rather than a more loose standard, reasonable rule standard if that speech activity isn't otherwise allowed in the library. In addition, the library can't impose regulations or restrictions on the use of meeting rooms or other public spaces open for use that exclude certain speakers or groups because of the content of their speech or because of the beliefs they hold, or their background, political views, or the groups they belong to. And this is particularly important for religious organizations as well. This requirement is absolute. A public library as a government agency cannot engage in any kind of discrimination based on race, sex, ethnicity, religion, gender, or politics. This is what the law requires of all government agencies and all government employees. But again, you can impose reasonable, content-neutral time, place, and manner rules on the use of library spaces. They can be limits on the number of times a group can use a meeting room, or limits on the level of noise, or a requirement that meetings held in the library must be open to the public, as well as requirements that anyone using the library's meeting room comply with the other policies of the library, such as behavior or harassment policies. Meeting rooms and display cases can be closed to public use, however, as you know, you're not required to offer these services, these resources to the public. And you know, you have to, and if it becomes a disruption, it might be a decision of the staff and the board to close access to these rooms. I've actually worked with libraries who've made that decision when it became too much disruption to manage use of meeting rooms and display cases in that particular library. You know, so to sum up, a written policy setting forth the rules and restrictions on the use of meeting rooms and display cases is critical. And if there's a concern from the members of the public that somehow there's endorsement of particular viewpoints or particular groups by letting them use the meeting room, or really it's their right to use the meeting room, the library can post a sign near the meeting room or display case, making clear that the views are the views of the group and not the views of the library or the library board. Now, another issue that's frequently come up in relation to libraries in the First Amendment is social media. And the use of social media platforms or blogs to communicate with the public can also become subject to the public forum doctrine. Now, like meeting rooms, libraries are under no legal obligation to participate in social media, nor are they required to host public conversations online. A library could choose, for instance, to solely participate in one-way communications on social media, not allowing comments, not engaging with the public on their social media accounts. But once a publicly funded library does invite conversation, does choose to open up their comment area, doesn't choose to engage in conversation, they will have been considered to establish a designated public forum on that social media account. You know, and this is really analogous again to meeting rooms or display cases. If you open it up for use for the public for an expressive activity, it becomes subject to the public forum. What this means in practical terms is that publicly funded libraries whose social media or blogs are open to public comment, they cannot remove comments based on viewpoint or content, nor can you block posters from social media platforms based on their identity or the content of their posts. If you recall, our former president lost a First Amendment lawsuit to Twitter users who were blocked from his account after posting comments critical of the president. And there have been similar lawsuits filed against other elected officials, other public agencies around the country, when those agencies or those public officials chose to block users or erase comments placed by the users on their social media accounts. So again, this requires thoughtful use of social media and a written policy addressing the mission and the purpose of the library's use of social media, and creating an acceptable use policy, similar to the acceptable use policy created for internet users, that clearly explains when and if any kind of content moderation might take place. Content moderation, again, can't be based on viewpoint or criticism of the library. But if there's the use of profanity, a threat of defamation, there might be an opportunity to take down those kinds of comments, and your policy should be written to consider that in consultation with your legal counsel. But let's get to the nut of what we'd like to talk about, at least here in the Office for Intellectual Freedom. And that's the First Amendment right to read, the First Amendment right to receive information in the library. Once libraries make information available by placing a book on the shelf or by providing access to internet platform or information resource, courts have found that any removal of library materials have to meet certain requirements imposed by the First Amendment, because removing or restricting access to a library's users' access to those materials can constitute an abridgment of their First Amendment rights. Restrictions on receiving information from the library are unconstitutional if they place an outright ban on receiving information or impermissibly burden the ability of a person to receive information. This can include the relocation of books already in the collection to another area of the library if it's done to prevent the intended reader from seeing or borrowing the book. And this is where minors' rights come into play. This also includes moving books from the children's collection to the adult collection on the grounds that somehow they're unsuitable for minors. So no government entity, including public libraries or public school libraries, may restrict or censor materials because of the viewpoint expressed by the author or publisher. And if the public library or the public school library removes any book because it disapproves of the content of the book, there's really only one way to make that legal, and that's to prove through the strict scrutiny test that that you've met this very high barrier, demonstrating that there's a good reason to remove the content that meets the First Amendment standard. To do this, the library or school must produce evidence demonstrating that there's a compelling interest in removing the material, and that effort to remove the material is narrowly tailored to achieve that compelling interest in the most narrow fashion. And that is that you're not restricting any more speech than necessary to achieve the interest and to limit speech. This is a very difficult test to meet. Courts, including the Supreme Court, almost never find that a library or other government agency meets this test if the government's actions result in content discrimination, viewpoint discrimination, the censorship of constitutionally protected speech. Now, as I mentioned earlier, school boards do have greater discretion over their libraries, but that discretion is not absolute, as the Supreme Court noted in its 1982 PICO decision. However, if the school board can provide evidence that a work is educationally unsuitable or pervasively vulgar, courts have upheld the removal of a book or restriction on materials in school libraries. But again, circling back to minors' rights, students do have First Amendment rights to receive information. Decisions to remove materials from classrooms or libraries must be backed by evidence and fact-finding that supports the conclusions that the material is educationally unsuitable or pervasively vulgar. Reconsideration policies that require the evaluation of books or materials must make sure that the material is evaluated as a whole and in light of the collection development policy, and that will be an aid to this evaluation. Furthermore, if it can be shown that the removal of the restriction on a book or other material was done for a discriminatory purpose or a politically partisan purpose, it may be overturned as a violation of students' First Amendment rights, even if on its face the restriction appears to comply with the Constitution. So let's talk about what's not protected by the First Amendment. So many of the challenges and complaints brought to school boards and library boards today claim that books in school libraries and public libraries are obscene, pornographic, illegal. And so for this reason, I'd like to really explore deeply what is unprotected speech and talk about our obscenity laws. So there's a clear understanding of the current legal precedents and statutes addressing illegal speech. First, courts start with the premise that all speech is, excuse me, just a second, I'm sorry. Little dry there, I apologize. Courts start with the premise that all speech is protected under the First Amendment, unless it falls into a category of speech that is not protected. These categories include obscenity, child pornography, defamation, false advertising, and fighting words. The Supreme Court has also identified a category of speech that is protected by the First Amendment for adults to view, but is considered to be obscene for minors and thus is limited for minors. This is what's called obscenity for minors or harmful to minor speech. The Supreme Court decisions defining the categories of unprotected speech are considered federal law that applies to states through the 14th Amendment, so they are fully applicable and should be considered when talking about this issue. What this means is that state laws addressing illegal speech should conform to the definitions and requirements set by the Supreme Court regarding unprotected speech. Now, the test for determining what is harmful to minors or what is obscene for minors is the same test as used for adult obscenity. Now, I should note here that many states exempt librarians and teachers from their obscenity or harmful to minors laws in recognition that in the course of their work as educators or provider of information, they may be sharing information about sex, gender identity, or other controversial topics with minors for an educational purpose, and thus the law protects them from having from being charged under those laws if they are providing that information for that educational purpose. Now, the Supreme Court has crafted a three-part test to determine whether something is actually obscene and unprotected by the First Amendment and subject to regulation or removal. The first part of the test is whether the material depicts or describes particular sexual conduct that is defined and identified by state law, and that depiction must be done in a patently offensive way. Then the court will ask if the material being challenged is something that the average person, looking at the material as a whole and applying contemporary community standards, would conclude only appeals to the prurient interest. That is it only being offered for the purpose of sexual excitement? I had a law professor who described this little bit of the test as a question of whether it turns you on and turns you off at the same time. And finally, the judge and the jury must ask whether the work as a whole lacks serious literary, artistic, political, or scientific value. Now, it's important to know that the Supreme Court has said that this is a determination that can only be made by a jury or judge acting as finders of fact in a court of law. It's not up to an individual or an elected official to decide that a work is obscene based on their personal subjective beliefs. Second, under the test mandated by the Supreme Court, the book or material must be evaluated as a whole. It can't be judged obscene based on a single passage or a single image, or simply because it depicts nudity, uses profanity, or references gender identity or sexual orientation. Now, as I said before, the test for what is harmful to minors is the same test as the test for what is obscene for adults. But the three-part test is applied and considered in the context of offensiveness and serious value for minors. And that determination has to be made in light of the oldest of minors. That is, you can't think of what's obscene for a 5-year-old as the baseline. What the courts have said is that if it has serious value for a 17-year-old minor, it's protected for all minors of all ages. It's also important to note that even though materials might be unprotected for minors, we have to remember that even though it's unprotected for minors, it's likely still to be protected speech for adults, an important consideration, especially for public libraries. I will observe at this point, given the controversies that we're seeing, the headlines that we're seeing, that any materials available through booksellers, mainstream publishers, online stores, including many of the books that are among this year's most challenged books, do not meet the legal definition of obscenity or even harmful to minors. I promise you that few, if any, publishers or content providers would risk being charged or sued under obscenity statutes, and will not be putting that material into the mainstream of commerce for acquisition by readers, libraries, schools. And I will also note that the term pornography has no legal meaning. It's a colloquial phrase that some use to stigmatize materials that they object to on moral or religious grounds, but that phrase does not identify what is unprotected by the First Amendment. Many states provide anyone in possession of controversial materials an affirmative defense who in the course of their work as educators or information providers are sharing such materials, as I mentioned earlier. It's important to remember that to check for this protection in your obscenity statutes in your state, and to make sure that if you that it's part of your policies if in fact it exists. So one last consideration that we don't talk about often enough anymore, and that's internet filtering. I know that it's become part of our common practice, particularly because of the Children's Internet Protection Act, that ties the use of filters to the receipt of E-rate funds that underwrite so much of the broadband access that's available to libraries and schools. As you know, under the Children's Internet Protection Act, anyone who uses E-rate funding or LSTA grants to pay for their internet access must install and use an internet filter to block photographs or images that are obscene or child pornography for every user of any age. The filter must also block certain images that are protected speech for adults, but deemed to be harmful to minors or obscene to minors under the law. The blocking of content is authorized because the Supreme Court held that the First Amendment does not prohibit Congress from requiring public libraries from using filters to block access to images that are unprotected speech as a condition of receiving federal funding, as long as adults can request that the filters be disabled or sites unblocked without needing to explain the request. I will say that SEPA has been broadly misinterpreted to require far more censorship than the law requires. Remember, I said that it requires the blocking of images. It does not require the blocking of texts. And also, SEPA employs the federal definitions of obscenity and harmful to minors and only restricts access to those kinds of materials. That is, so there is no need to block access to things like, and this is things that we have seen happen, blocking access to materials, websites that deal with civil liberties for LGBTQIA persons, that talk about gender identity, sexual orientation, that talk about alternative lifestyles, or even alternative religions. All of those items have been blocked in the past by some libraries under the idea that it's blocked by SEPA, but that's untrue. So it's important to know exactly what the law requires and to fine-tune your filters to not overblock content that might be protected for your users under the First Amendment. And again, I'll reemphasize, SEPA doesn't authorize viewpoint discrimination. So I actually, there was one school library that blocked access to pro-LGBTQ websites and allowed access to things like ex-gay ministries or sites that argued against civil liberties for gay and transgender people. That's viewpoint discrimination, and it's simply not allowed. And the ACLU successfully sued that school district for viewpoint discrimination, and they paid a hefty amount of money to the ACLU for violating students' First Amendment rights in that way. And one thing, last note about the Children's Internet Protection Act that not many people know, and that's the Children's Internet Protection Act explicitly forbids its use as authority to track users across the internet. That is, it's not an authorization to track their data, keep track of what websites they look at. It protects library users' right to privacy and what they view and browse on the internet. And this extends to minors as well as adults. So it's important to make sure that when you're considering your use of the internet, when you're writing your acceptable use policy under SEPA, that you need to protect the privacy of users when you do that. So one last review of general policy guidelines that can help you in writing policies that incorporate these First Amendment guidelines. The primary means of protecting library users' rights really is written policy. And it also is a way of making sure the library can operate in a fair business-like manner that conforms to the law. Written policies inform the community about the library's mission and goals and how the library intends to achieve them. They also provide the community with the means to evaluate the library's performance and show that the library is willing to be accountable for its decisions. Overall, the goal is to demonstrate to the public that the operation of the library, its provision of services, and its acquisition of books and resources is not a haphazard process or the result of a partisan or political agenda. Written policies dispel some of the most noxious claims of library critics. They can serve as evidence of libraries' normal practices and the fact that the library's practices, especially collection development, are based on thorough research, careful planning, and sound judgment. And these policies are also useful in court. We can think about the lawsuit brought by the barefoot library user. Library that provides that evidence that you need to show that your decisions that are being made are according to regular policies that have been thoughtfully considered, that have reasons behind them that can be identified in court. This is important, especially now in a time when library and staff members could be sued or are being sued. It's really not a remote threat anymore. We've assisted libraries that have seen criminal charges filed against them for allegedly pandering obscenity, for example. So it's important to have written policies in place for your collection, for reconsideration, that will dispel some of those allegations. So, and while libraries can adopt a detailed range of policies concerning the library's operations, we consider 5 policies essential for every library and essential for the defense of the right to read and for the protection of the staff. And this includes the collection development policy, the reconsideration policy, the internet use policy or acceptable use policy, and that behavior policy that establishes rules for the use of the library. Behavior policy, and augment that all with policies for your meeting rooms and display cases if you have them open. Again, social media, and any other policy that's required for use of the library. I think now so many libraries have maker spaces or teen areas that include things like 3D printers or recording studios for podcasting. You have to have a policy for those as well. And then don't forget your privacy policies that address how third parties might or should not really get access to user records, and the library's commitment to protecting users' privacy. Really, that's the subject of a whole nother webinar, but I want to just put a pin in that so that you make note of that as well. And the last thing I want to say is that you really need one last policy or one last commitment, one last mission statement. And that's a statement that identifies the library's commitment to intellectual freedom, the defense of the freedom to read, and opposition to censorship that includes books and resources intended for the use of young adult readers, which are so frequently under attack today. The intellectual freedom statement should incorporate statements of professional principles, such as the Library Bill of Rights and the Freedom to Read statement, as well as adopting the ALA Code of Ethics as a guide for library workers. Remember that the Library Bill of Rights specifically defends the rights of young people to access the library books and resources free from censorship, and we should always keep this in mind as we deal with the current spate of challenges in libraries today. Now, before I conclude, I want to share one last set of data, what we're seeing in regards to book bans in schools and libraries across the United States. In 2022, ALA saw the highest number of attempted book bans since we've been compiling data about censorship in libraries. And we began compiling this data back in 1990. We had 1,271 reported book challenges in 2022. And that targeted 2,571 unique book titles. I mean, think about this. There was attempts to remove over 2,500 books from libraries across the United States. And the vast majority of those titles were books written by persons who were LGBTQIA or persons of color, particularly Black persons. And these numbers reflect a really disturbing trend, that this is an organized campaign It's no longer a conversation between a parent seeing their child read a book, look at that book, and to have a conversation with a librarian or an educator. What we're seeing now is these groups like Moms for Liberty, No Left Turn in Education, Parents Defending Education, pursuing a political agenda to sanitize library shelves according to their particular tastes. I have to tell you, 90% of the challenges last year were to multiple titles, and 40% of the challenges brought in 2022 in libraries were to 100 titles or more. We need to be aware of these trends and to prepare ourselves, our staff, our board, our community to defend against these efforts to censor library books. And I also want to point out that it's not just book banning that's going on at the local level. We're seeing efforts by elected officials to buy into this narrative about harmful materials in libraries and to impose legislation, adopt laws that restrict access to materials for primarily young people, but also for adults. We're seeing these bills, Don't Say Gay, anti-divisive concepts bills that restrict what can be taught and shared in K through 12 schools and even universities these days. Efforts to target materials that touch on issues around sex, gender identity, and sexual orientation in public libraries, whether it's criminalizing providing access to books. Where we've seen this happen is North Dakota, Missouri, laws that actually make it a crime for a librarian to provide books touching on things like sex ed to a minor without a parent's permission. We're also seeing attacks on funding mechanisms. Just yesterday, the Missouri House of Representatives voted to defund public libraries because they don't like some of the books that are on public library shelves. We're hopeful that that will be turned away by other legislators in the state of Missouri, but it's a real trend. And the other thing we're seeing, and I spoke about this earlier, I noted that often obscenity laws have exceptions for those handling materials for educational purposes. There is an organized campaign by a number of groups to pass model legislation that strips those legal protections from librarians and educators. We're seeing proposals to substitute the judgment of professional librarians with parental and political oversight boards, targeted regulation of research databases like EBSCO, ProQuest, and Gale, often based on the false information that they deliberately include obscenity in their content for young readers. And we're seeing more frightening proposals. They'll propose laws that say, sexually oriented materials are not permitted for minors in public libraries, but they don't provide an enforcement mechanism through the government. What they do is they provide parents and minors the ability to sue the library for providing those materials to a minor, and they'll attach a fine to it or some other similar penalty. And so a library could be sued by a private citizen for having materials on the shelf that a parent disagrees with. And this evades constitutional review under the First Amendment because it's not the government removing the book, it's a parent suing in a private civil action to remove the book. And this is a real danger. And it's not just book burning, there are other civil liberties that are being threatened by the same kind of bounty bill that enables private citizens to enforce a law rather than the government. And we're also seeing local initiatives, things like the Abilene Resolution, which would adopt oversight boards and private rights of action for local communities. So, it's hard, it's hard to think about all these challenges, all these threats to right to read, but there is a way forward. And the way we go forward is going through it together. Some of you are familiar with ALA's public-facing campaign that's intended to empower advocates everywhere, not just librarians, but members of the public, your users, communities as a whole, to fight censorship in libraries and to beat back this campaign to keep information from the community. And so the Unite Against Book Bans is designed to empower all supporters of the right to read to become informed, to speak up, and to join together. We have over 76 national partners and a growing list of state and local partners, including many ALA state chapters, to fight against censorship in their communities. I encourage you to join the campaign, share the campaign with your colleagues, with your communities, and really spread the word so we can develop a very loud voice to fight censorship. I also want to encourage you to visit the toolkit that has materials to help advocates in your community engage with local officials, the press, and with each other to fight censorship on behalf of the library and its staff. We have nonpartisan materials that are intended to empower voters to understand where candidates lie and to encourage candidates to oppose censorship as part of their election agenda. And we also have white papers that support the availability of diverse materials on library shelves to improve literacy, to improve educational outcomes for young people. Those and similar tools are available to everyone. And just a note, I don't have an image to show you today, but put April 24th on your calendars because that's the first day of National Library Week, and that's going to be National Right to Read Day. And on Monday, we'll be sharing with everyone a set of action items that they can do in celebration of Right to Read Day on April 24th. Now, as one last thing, for all you legal nerds out there, I've created a slide, and I will share these slides with you later, that cites to all the court decisions that that supported the information I provided to you today. So if you want to go back and do some deep reading, here's all the citations. But I'll conclude with that now and welcome your questions, your thoughts, your ideas. I can put the slide up later, but it's probably best if I stop sharing and we can have a conversation together. Thank you. And again, thank you for your patience in having me with the presentation and having me here today. And I'll look at the chat.
Thank you, Deborah. Actually, Valerie has her hand up. Val, if you want to go ahead and unmute.
Hi, Deborah. This is Valerie Nye.
Hi, Valerie.
Hi, good to see you. And thank you for providing in about an hour what we could learn in 6 months. It's just, you have provided a semester worth of material in such a short amount of time. And I just simply want to thank you and the Office for Intellectual Freedom for all that you're doing right now and supporting libraries. I know it's emotional work and difficult work, and a lot of change is happening. And I just want to thank you so much for the hard work you all are doing.
I'll thank you. I want to thank you on behalf of the office staff. Many of you may not always know their names, but Eric Stroshane, Joyce McIntosh, Betsy Gomez, are all doing yeoman work in supporting individual librarians and community activists across the country right now in fighting censorship. And they're really engaged in this work, and we all should keep them in mind. But I really want to keep in mind all of you on the front lines. Valerie, you've done such great work yourself in defending the freedom to read and getting the word out. And I think that's the way forward. As I said, we all have to hang together and raise our voices. And we're getting, they got a jump on us. Let's be honest about it. These campaigns knew what they were doing. They're well funded. They're tied to many of the things like Heritage Foundation. But we're catching up and we're succeeding. We're seeing governors veto harmful bills in Idaho, for example. We're seeing elected officials in Congress step up and raise their voices against censorship. We're seeing school library boards vote to retain books rather than remove books after all the advocacy we've been doing. So advocacy is effective. We have to just raise our voices together and understand, and then support each other. I think it's important to remember that we're all, it's one giant library ecosystem. And, if you're a public librarian or an academic librarian, you may be able to attend a board meeting and speak out in defense of a school librarian who may not be able to raise their voice or may not be able to talk about the First Amendment, the Library Bill of Rights, minors' rights to read. We all have to defend each other, or even just simply providing emotional support to a colleague who's going through a difficult challenge. It's so important to do that work right now. And we try to provide all the resources we can through ALA to facilitate that work. Different offices are doing different things, but we're here for you. And, I can go back to the other slide, but everybody's welcome to write at oif@ala.org. Or call us at 1-800-545-2433, extension 4221. And Karen is usually the person on the other end. Karen Giannini is the fourth member of the staff, and she's usually at the other end of that line, and she'll make sure you get in touch with the person you need to talk to for help, assistance, or support. So are there questions if anyone has? I know I dumped a lot of material on you. There's certain to be questions for anyone, and I'm happy to try to answer them. I think we have about 15 minutes left. And let me see. So yes, I will provide a copy of the slides. So, but again, it's important to know all these things about the law because there's so much disinformation and misinformation being spread about books right now. Particularly controversial titles like genderqueer. Often you'll get claims that the book is illegal pornography. It's in fact gone under court review in Virginia Beach, Virginia, where a judge determined that in fact it was not only protected speech for adults, but protected speech for minors to access. And that's one of the roles of our office. We can provide you with those legal authorities so that you can share them with your boards, with your administrators, with the attorneys that are representing your library boards or your school boards. So Ellen, I think that's all I have. Is there anything else that we should do today?
I don't think so. Thank you for a very comprehensive overview of really important issues. And yeah, we really appreciate your time and effort in coming to speak to us.
Oh,
so it
and
looks
I
like we do have a question. Did you see the question, Deborah? I think.
Yes.
Oh, there is one.
Drag story times. So there are a couple of issues with drag queen story times. One is that if you have a meeting room and you open it to the public and a community group wants to do a drag story time in the meeting room, they have every right to do that. And in fact, you can't bar them without inviting possible legal action. I'll be honest about that. That would be considered content and viewpoint discrimination if you allow the public to use your meeting room. But you can also make it clear that you make your meeting rooms available for use by the public and that you cannot discriminate, and that the fact that a drag story hour is going on in your meeting room is not necessarily a sign of endorsement. If you're a library who does want to sponsor a drag queen story hour, you're entitled to do that. And the problem is that there's a lot of effort being put into stigmatizing drag entertainment as somehow obscene or sexual, when we all know that it's not that. I mean, I think of it's not, but we can think of past examples like Some Like It Hot, Tootsie, the Birdcage, all kinds of entertainment that utilize drag performances, so that it's important to have talking points on hand that emphasize that drag performance in and of itself is not sexual and does not have to be sexual, and that someone in costume reading a story hours is someone in costume reading a story. And working with supportive community organizations. I know that GLAD, PFLAG, other organizations like that will support the library, actually will come out and do defense when there's a story hour. But it also involves gaining, working with your board, working with your elected officials, establishing that relationship of trust long before you plan programming that might be controversial, so that when a controversy does arise, they go to you, they trust you for good information about what's going on, and they trust your judgment, and they'll support your decision making about that. That's really kind of advocacy 101, is having networks of support already in place, or developing those networks of support for the library, its services, and its staff. And then not being hesitant to call for assistance. New Mexico Library Association, ALA, other organizations are always anxious to advise and support and make connections if necessary. But do know that drag performance is protected expression under the First Amendment. Don't let anyone tell you otherwise. And it can be a hard slog arguing against people who've been fired up on Facebook and other social media, Twitter in particular, but having either, if you're hosting a drag performance for Drag Queen Story Hour, that's a programming decision that the library and its board can make and offer to the community. And many people in the community, many families in the community welcome that kind of programming. And they shouldn't be denied access to that programming because there are some who object to that. It may mean talking about the role of the library, offering other resources. There was a pastor who would go in and do a pastor story hour. Fine, we're open to all ideas and all viewpoints and things, and that's fine if that's what results from the conversation in your community. And if it's a group using your meeting room, having that written policy in place, those statements in place that explain that it's a public forum, that you're required to provide access to anyone who is eligible to use the library, and that and if that statement that says that that's offered to the public, that doesn't imply endorsement or anything more than the fact that someone is using the library. So I hope that's helpful. We haven't seen a court case yet where we have seen attempts to charge librarians with crimes. It's been around primarily books for young adults dealing with gender identity, sexual orientation, or sex ed materials, like It's Perfectly Normal. But I'm just waiting for something to happen. I hate to say that I anticipate that kind of thing, but we'll learn more if it does. And one last thing before we adjourn, I meant to mention, and talking about the standards about library censorship, the victory in Llano County, Texas. A group of brave citizens stood up and sued the public library in Llano County when they removed some 20 plus books out of the collection and completely disconnected access to the ebook platform that was being used by the library because they didn't like some of the books on the, well, as a minority of library users who thought some of the books were pornographic. And I can assure you that none of the titles were, and many of them were books dealing with race and racism rather than anything dealing with sex. The judge issued an order last week requiring the library to return all the books to the shelf and place them in the circulating collection for library users to access freely. Upheld all the legal precedents regarding the First Amendment and access to books to library, that, it's not that library users have First Amendment rights, that libraries can't remove books simply because they don't like the ideas in the books. And that when a library removes books because of viewpoint discrimination or content discrimination, they'll be liable for the violation of their users' First Amendment rights. If you're interested in that decision, just write oif@ala.org and we'll be happy to make a copy of the decision available. You can also find it on our blog at oif@ala.org/OIF. And I'll finish with that.
There's a hand up.
Okay, great.
it's not so much a question as I just want to say, I really appreciate all the information you've given us, because all day long we've been saying, write policies, write policies, write policies. And this is, I mean, you wouldn't want to put all of, actually all the detail in the policy, because then the policy would be 100 pages long, but you've given us so many wonderful bullet points for anyone who doesn't have a policy or isn't sure how to write the policy or isn't sure what their rights are. You've now given us this to put this in the policy and say, this is the First Amendment right. This is, this is what pornography is defined as. And I think those are great things to at least link the policies to, even if not, in the document itself. It's like, if you have a question, look here. So I really appreciate that. And I think that's going to help a lot of us. I mean, we have a policy, but on my notes, I review this policy. I review it all the time, but I'm going to review it again after today. And I think this is incredibly helpful and useful information. So thank you so very much. And then I think we've got one other hand. So.
Yeah, can you hear me at all?
Yes, I can hear you. Emily?
Oh, yay, so wonderful. I was having some issues with my microphone in an earlier session. So I guess my question would be, is I work in a special library that is oriented towards individuals with disabilities, and particularly children with disabilities. And not only are we looking to develop a formal collection policy, because we haven't had one up until this point, but we've had several questions recently about if we have materials on gender identity for teenagers and youth with autism. And obviously I want to have a collection development policy in general because of how important they are, but I'm particularly concerned that I'm gonna maybe run up against extra backlash because the children that we're working with do have disabilities.
Yeah, I mean, certainly you want to, have a policy that takes into consideration every child's needs. And, for your library, which is a special library, you make that part of your mission statement. There is a great resource on our website, the Selection and Reconsideration Policy Toolkit. It's free, it's multi-page, but it's guidance from public school and academic librarians on how to draft an effective collection development policy. And I would be happy to connect you with our both ODLOS, well, I'm using acronyms here, but we have an Office of Diversity and Literacy Services, and CORE, which is our division that deals with special libraries and their administration. And certainly there's resources there that we can help with. I know that CORE administers policies and works with special libraries that might be helpful to you. So write us at oif@ala.org. And you'll probably either hear from Eric or Joyce, and they'll help facilitate that. But you can take a first look at the selection and reconsideration kit on our website.
I guess part of my question would also be if I get questions from parents. I know in the past I have had at a public library, I've had pushback from parents who are the caregiver for a child with a disability. So if our policy is, the child needs to be there to make a card. One time I got a lot of pushback from a parent being like, but that doesn't apply to my kid. My kid has a disability. I'm their caregiver. I just want to make sure that there aren't any extra legal considerations that we would have to think about.
It's a tough area. And, we look at young people and we know we're dealing really with a range of capabilities and interests when we deal with minors. It starts at age 0 and goes to age 17. You can't think of two different groups of people, right? And so it's okay to have library cards that recognize that maybe like someone under 7 really needs someone supervising their library use, or to have, many libraries now have adult supervision roles, and in part to defend themselves, that a child can't be in the library without adult supervision if they're under the age of 10, for example, or age restricted library cards that for young people. But I would always strongly recommend that we recognize particularly the First Amendment rights of mature minors in this case. One, I will tell you that here in Chicago, where I live and work, the Chicago Public Library has essentially what's a family card for young users. The parent is responsible for the card. The kid may have their own card for checkout purposes, but it's an account maintained and administered by the parent with the child as a subsidiary. That ends at the age of 12. When you're 12, you get your own card. Parents don't have, and you're held as responsible as an adult once you reach the age of 12 and can freely use the library without your parents being involved. So there's many different approaches to this that are thoughtful about the consideration about the different range of abilities. And it may be important for you, given that some of your users have autism or something like that. And it might be just having respect for the individual student. If they express a preference to you, or if they're asking questions, that's being willing to recognize their special needs at a particular moment is perfectly fine, I think. We do recommend, though, these days that there be an opt-out provision for parents. Many controversies about books can be forestalled by having a provision in either the reconsideration policy or the collection development policy that allows a parent to say, I'm guiding my child's reading. I don't want my child to read a particular book. It will often help forestall a demand to remove the book from the library as a whole, giving the parent the ability to opt their student out of a particular book or reading assignment. It's not ideal. If we can avoid it, we do, especially for the older adolescent who is certainly exploring ideas that they don't want to talk to any adult about and should have the liberty to do that. And crafting a policy that considers that is important as well. I know that YALSA in particular has a number of recorded webinars that addresses this particular issue as well. And that might be another resource to turn to, is our youth divisions that work with young adults and with services to children as well. So I hope that's helpful. Great, thank you. Are there other questions? I did see a statement about presentations to library boards. We're happy to work with library boards and to arrange for private presentations as well. And it's not just myself, Teresa Camara, who's general counsel for the Freedom to Read Foundation, and that's the other hat I wear as executive director of the Freedom to Read Foundation. Often will be willing to meet with a group of board members to talk about First Amendment issues as an attorney who's litigated First Amendment issues for 30 years. And I'm also happy to do workshops with trustees as well. And there are great resources available overall at United for Libraries. It's our division for library trustees and friends groups. And they've been very dedicated to developing a suite of recorded education opportunities for trustees, especially new trustees who are just stepping into the role, that help them understand their roles, not only in the realm of intellectual freedom, but fiduciary duties, finances, public responsibilities as well, public management responsibilities. So if you have a board that's interested in that, we're happy to make those connections too. And let's see, I think that's all I have. And we're 2 minutes from time. So if there's any last minute questions, I'll be happy to take them. And if not, I hope you all have a wonderful weekend and a wonderful afternoon. We're enjoying great weather here in Chicago. It's, just about 70 degrees and all the flowers are out for the first time. And I, again, thank you for welcoming me here and spending some time with me today. And please don't hesitate to reach out if you ever have a question or need any help. We're always here for you when it comes to the issues around access to libraries, intellectual freedom, First Amendment law, anything, we're here to help. Thank you.
Thank you again.
Thank you.
Thank you, Deborah. And thank you to everyone who was able to attend today. I appreciate, being able to take the time to visit either all of our sessions today or just this one. We will be making the recordings available